we will be talking about a case called Pappas Enterprises versus Commerce Industry Insurance Company, 1996. So let's get on with the facts. Plaintiffs signed up for the policy in September 1, 1988. Remember this date? And the next important date is that the property, one of the property, it says numerous properties in Boston, but one of the property becomes vacant in May 1989. So as we know, generally insurance policies are to be renewed annually. So the second issuance or the second period of the policy and the first renewal of the policy starts at September 1, 1989. So from September 1, 1988 to let's say October 31st or October 30, 1989, the first policy acts, or the first policy exists. After that, the second policy exists, and the second renewal of the policy is a year after that in 1990, September 1, 78, or later year. And last, the very important date, or another very important date is the property damaged by fire, which is on October 27, 1990. These are the facts that we have to remember. So the petition is that the insurer declined liability for fire loss, and the insured or the plaintiff does petition in the United States District Court for the District of Massachusetts. And in defense, what the insurer said, what the defendant said, is that they relied in the policy language that excluded liability for a loss occurring while the described premises are vacant or unoccupied beyond a period of 60 consecutive days, which is on the general law of the Massachusetts, chapter 175, section 99, 12th edition, published in 1994. So in this language, if the properties are vacant beyond a period of 60 consecutive days, then the insurance company do not have to provide any insurance at all. The defendant contends that the property had been vacant for over a year, since the property had been vacant around May of 1989, and the event of fire broke out in October 27, 1990. So the defendant contend that they do not have to provide the insurance. However, the plaintiff argued that the 60 days vacancy period has not passed, because we have to count the days from September 1, 1990. They have to take the second renewal of the policy or the third policy period to count the vacancy period, because only 57 days will have been passed if they count from September 1, 1990, which is under 60 days of the vacancy period. So they are entitled to the insurance as per their arguments. So the court have to look at which date to issue, from the date that the property had been vacant or from the date policy renewal came into effect. So that's the petition that we have already talked about, and the district court found it quite hard because the policy provision was inherently ambiguous. There was no controlling Massachusetts authority that could say that it was right or it was wrong decision by the insurance company, and the cases as well relied on factors not applicable in the circumstances of this case, and the ambiguity is contained in every fire insurance policy written in Massachusetts. So, but the Supreme Court of Massachusetts found out two issues that needs to be answered for the decision of a case. So the first issue is, does the 60-day vacancy provision for fire insurance policies prescribed by the general laws, chapter 175, section 1999, apply in the case where part of the 60 days of vacancy occurred prior to the day the policy came into force? Suppose if property had been vacant 30 days before the policy came into force, did the 30 days that was passed before the policy came into force would be counted in the 60 days vacancy period? That was the first issue. And the second issue is, will the result be different if the vacancy provision would apply in the first case? Yes, the vacancy will be counted in the 60 days vacancy period, where the policy enforced at the time of the fire was a renewal of an immediately preceding policies, and a portion of the period of vacancy beyond 60 days occurred during the immediately preceding policy period. So it's the same, but what if it was the renewal? So the part of the vacancy occurred before the renewal of the policy. A policy was already in force, and vacancy started in this period, and some part already passed, and some days already passed, like 30 days. So suppose again 30 days passed, and when you renew, does the vacancy periods again start from the zero or stack up to the already 30 days? So that was the second issue. And now let's see the relevant laws. As you guys have already figured out, the main law that needs to be analyzed and needs to be interpreted by the court is the general law, chapter 175, section 99, that we have already talked about. So in here, to reiterate, it will re-strengthen our memory. Policy state that unless it otherwise provides, the insurer of the premises of the kind involved in this case shall not be liable for the loss occurring while the described premises, whether intended for occupancy by owner or tenant, are vacant or unoccupied beyond the period of 60 consecutive days. If the premises hereby insured shall become vacant by the removal of the owner or occupant and so remain vacant or for more than 30 days. Sentence that I have just now spoken is the earlier law that was before 1951. So the law in the second point gives the law of the same law which was prior to the 1951 amendment. So in here, so this is the main relevant law and the only law that we have to question upon. So this is the only law that the court has to interpret and give an answer to the questions posed by the circumstance of the case. And the law in the second point is the law that was in effect prior to the 1951 amendment of the same law. In here, if the premises hereby insured shall become vacant by the removal of the owner or occupant and so remain vacant for more than 30 days. So keep in mind the language used here and the difference in language. It says shall become, and in here it says are vacant or unoccupied shall become vacant. So it's different, and we can, or the court has construed that the legislature intended to move away from a prospective vacancy and move towards the already existing vacancy. So we can also construe the change in the language in a similar manner. And in the case Weiner versus Milford, a Mott Fire Insurance Company, the court construed that the formal language to mean a vacancy of 30 days commencing while the policy was in force. So in here, the language shall become vacant was used by the court at the time in 1981, meaning that the vacancy only started when the policy was in force, not before the policy was in effect. So the court speculated that the words shall become vacant pointed to a prospective event of future vacancy, and the language are vacant, which replaced the formal language, has been consistently regarded as referring only to a vacancy occurring after the commencement of the coverage. Looking at the application of the law of the general law in issue number 1, it says that the words shall become vacant pointed to a prospective event of future vacancy. So the court construed that the language in here shall become vacant meaning to a prospective event, and the legislature in removing it, meaning that it could be considered that the intention of the legislature was to move away from the prospective vacancy, future vacancy, and move towards a retrospective vacancy, meaning that the vacancy will be counted before the policy was in force, not after the policy was in force. So the court construed that the legislature would mean that way. but it was not relied upon in this case. It was relied upon on other factors such as the language R backend, which replaced B or become backend, has been consistently regarded as referring only to a vacancy occurring after the commencement of coverage. So that was decided in Home Mud Fire Insurance Company versus Pierce, Olivera versus Hartford Fire Insurance Company, etc. And there are also some opinions holding that the entire vacancy must occur during the policy period. Resolve the policy ambiguity by reliance on the principle that ambiguity should be construed against the insurer because they have the ability to pay rather than the insurance. It will leave the victim uncompensated for the damage. So that was also decided in Home Insurance Company versus Pierce. The period of a vacancy existing prior to the date coverage is first effective should not be counted in determining whether a vacancy that excludes liability has occurred because of the following reasons. The first one is the interest in giving Section 99 the same treatment that is given to identical language in policies issued in other states. The other states practicing the same policies of insurance coverage were giving the vacancy period only after or counting the vacancy period only after the commencement of the policy, not before it. So they will give the same interest to the state of Massachusetts as well. And the opportunity an insurer has to determine whether a vacancy exists at the inception of a policy and to choose not to underwrite the risk, to amend the policy provisions where permitted or explicitly to provide coverage at an additional premium. It was decided in Commerce Insurance Company versus Coates. Because this reason reinforces the responsibility of the insurer because the insurer has the chance to look at the properties himself whether they have been vacant or not. So this second reason reinforces the idea of responsibility of the insurance company because while issuing insurance, of course the insurance company will look at the property and decide whether to underwrite the risks or not, to whether to take the risks or not. While checking the property, you will also have to check whether property has been vacant or not. So during the course of this inspection, of course you would have to decide upon whether to give vacancy to this vacant property or not. So there is the opportunity for the insurer to save himself from the damage, or he can also insure the risk but he at extra cost. So it is the not everything could be done by the law. Something needs to be done by the insurance company as well. And the third reason is that both the insurer and the insured should reasonably have the understanding concerning the policy language, applying normal reasoning and analysis. So what will the reasonable parties or the reasonable insured and the reasonable insured would understand by the policy language? That means so this third reason gives some leeway to both insured and insurer to decide upon the matters of the insurance themselves. So there is the chance of that when they renew, also when they meet to renew the insurance or during the inception of the policy, the first issuance of the policy, they can discuss that. Not everything has to be done by the law. At this point, also reiterate it in the third point. And it is hardly reasonable to think that the policy period of 60 days would terminate before reaching the 60 days. If my property had been vacant 30 days earlier than the commencement of the policy, and if the policy or the law was such that the vacancy period is 60 days of 60 days would count before the commencement of the policy from the actual date of vacancy, then my property will only be insured for the 30 days. So that is opposite to law. That is less than what the law intended to do, only insuring for 30 days instead of 60 days. So my property has to be insured for 60 days on the assumption that there is no prior coverage. The court in deciding issue number 1 has said that in the issue number 1, on the assumption that there is no prior coverage, this is the first issuance of the policy, the court has decided that that the vacancy period will only count after the commencement of the insurance. So that is the answer for the issue number 1. Is let's go to the question at hand and we will answer. Does the 60-day vacancy period provision for fire insurance policies prescribed by the law apply in the case where part of the 60 days vacancy occurred prior to the day of the policy came into force? It is in negative. No, it does not apply where the part of the 60 days would occur prior to the day policy came into the force. Now let's see the second issue. Will the result be different if the vacancy provision would apply and does purpose? That means if we answer the first question in the affirmative, where the policy enforced at the time of the fire was a renewal of an immediate preceding policy, and a portion of the period of vacancy began 60 days occurred during the immediately preceding policy period. So in here the code assumes that we are renewing our insurance policy, and the such renewal did not involve any significant change in the policy. So in the case State Farm versus Chambers, the court denied coverage because the old and the only insurance contract was simply extended for an additional year by the payment of the premium for the ensuing year. So insurance was not given because the policy was in fact exactly same. The result should not turn, however, formalistic on whether a new policy substantially identical as to the damaged property was issued or the old policy was continued by its terms. And was the ideal approach? The controlling factor should be what the parties reasonably should have understood the language policy to mean. So it should not be formalistic as to whether there was some words changed or some sentence removed. The controlling factor should what the insured and the insurer reasonably should have understood the policy language. And no reasonable insured will believe that the vacancy premises will be annually covered. So it means that if I get vacancy period renewed every year, when I renew the policy as well, I'm getting my back-end property, which should not be covered by the insurance after 60 days, will be covered annually for 60 days. So in each year I renew the policy, I get 60 years of vacancy, meaning it will stack up. So if I renew for 2 years, I will get 120 days of vacancy period insured. But that is not what the law intended, and no reasonable insured would believe that, because the law states that the insurer only agreed to assume the risk for 60 days of vacancy. But if we renew annually, in this case up to 1988 to up to 1990, the insurance company will insure for 180 days instead of just 60 days. So the court concludes that the vacancy exclusion precludes coverage of the fire loss, assuming that the renewal policy is exactly the same. There is not any substantial change as propounded in Tazza versus Reliance Insurance. There will be no insurance coverage for the insured. In this case also, since it was a renewal, it was a third renewal, and the plaintiff contended that the vacancy period should count from the date of the third policy period and second renewal, but the court said no, because then the plaintiff will be covered in the year of 1988 also, in the year of 1989 also, in the year of 1990 also. So that is not fair for the insurance company. And the court also comments that they do not have the circumstances of the renewal before us, and therefore only comment in general terms. So this was the application of the law in issue number 1 and 2. We have got our answer. So the language in the policy of liability insurance is prescribed by the general law, chapter 175, section 99 of Massachusetts, excluding liability for losses occurring while described premises are vacant or unoccupied beyond a period of 60 consecutive days, does not apply in the case of the policy renewal period. If there was no prior coverage, the vacancy period will count from the commencement of the policy, but if there is prior coverage, the vacancy will count from the first prior coverage, not from the second renewal if renewal is done. So that is the conclusion, and this has been the Pappas Industries versus insurance company. Thank you for watching. If you have any questions, please comment down below.